Okay, thanks everyone for joining our first water program team webinar series hosted by University of California Agriculture and Natural Resources. And our first speaker of this webinar series is Professor Holly Dormus from UC Berkeley. Professor Dormus is a James House and Hiram Hurd Professor of Environmental Regulation at UC Berkeley. She is also a co-director of Law of the Sea Institute and co-faculty director, Berkeley Institute of Parks, People, and Biodiversity. So that's a mouthful. And pretty much, I think most of you probably know her work in environmental law and water policy, as well as the water rights. And so Holly came, she took a little unusual background as far as the academic training goes. She got her PhD in plant physiology from Cornell and postdoctoral at University of Missouri before switching from the plant physiology to environmental law. So that's kind of little not a career type that most people opt to. So we'll get to hear some of that insight during her talk. So Holly, take it away, and thanks for joining us.
Thank you, Safik, and I'm happy to virtually be here. I've been guessing that most of the people on this call wouldn't be water lawyers, so this may be a little bit basic, or I'll hopefully it will bring everybody up to speed. I wanted to talk about property rights in water and the extent to which they are and are not dynamic. That requires, let me see if I can get to the right thing to use my, there we go. That requires that I talk about property rights a little more generally at the start, because water rights are they're an aspect of more general sort of law of property rights. And in general, the history of Anglo-American property law is that it's been designed to promote stability, primarily because, well, I should say the law in general is strongly pulled towards stability. We want people to be able to understand legal rules and comply with them. We don't want them to be hit by a lot of surprises. And that tends to require that legal rules not change too abruptly, too fast, or too strikingly. But property rights, even more so, strong, stable individual property rights are thought to encourage long-term investment in property. And the sort of paradigmatic property that the Anglo-American system thinks about and developed around is land. And if you think about development of land, the socially useful things that we do with land, many of them require a great deal of investment that won't be undertaken if there's not long-term confidence that the owner of the property will continue to be the owner of the property, and that the terms of ownership will continue to be roughly the same. And it's not just economic investment that's promoted by stable property rights, it's emotional investment. And in the United States, we tend to think that the paradigmatic piece of real property, of land, is a family home. And people tend to be quite emotionally invested in their homes, as well as that being their largest economic investment. So stable property rights allow them to make those kinds of investments. And of course, they also promote societal peace by making clear that you can't get resources simply by seizing them from someone weaker than you. But property rights also have to accommodate change at some level, because circumstances change, what we want our resources to be used for changes, how many resources we have relative to demand changes, our knowledge about resources changes, and of course our societal values change. And as an illustration of all of these things, this is a picture of hydraulic mining in California at the Malakoff Diggings. Some of you may have seen the landscape left by this kind of work in the late 19th century. It's not a landscape we would choose to create now. Our circumstances are different. What we value from the land is different. And our knowledge about what that would do to not only this land, but the waterways into which the tailings were being dumped, and the length of time it would take to restore, or the impossibility of restoring that damage, changed over time. So we want our property rights to be stable but not too stable, dynamic but not too dynamic. And there's been talk about, there's been a theory for some time promoted by a number of economists that property rights evolve over time as economic efficiency dictates or requires. That as resources become more scarce, the benefits of these stable rules of allocation become greater, and at some point they exceed the costs of having a legal regime, because it's not costless for the government to create or enforce property rights. And the tacit assumptions of this evolution of property rights story are that evolution does and should run towards stronger individual rights, and that it will occur, that change will happen as needed to serve economic efficiency. It's a happy story if you think economic efficiency and individual property rights are the right the goal, or the best goal. And one of the reasons that these folks promote this economic efficiency story is that strong property rights do facilitate reallocation to some extent. So as circumstances change, as knowledge changes, as societal values change, we want other things from our resources. And we therefore want our resources to be reallocated to people who will put them to what is now the highest and best use. And if individuals have strong, stable property rights, that makes it relatively easy to market those rights, to trade those rights in markets. And for these efficiency, evolution of property rights advocates, markets are and should be the primary mechanism for rapid adjustment of property rights. And the primary factor needing adjustment is who holds those property rights, which is something a market can change. At the same time, the idea is that the changes in the law of property rights should be fairly slow, because if what we want is strong, stable, individual property rights, we don't want too much destabilizing change. Now, there's been quite a bit of change in property rights over time, but the changes have not been rapid, and they've been accompanied by controversy and conflict. So there have been changes, for example, in the doctrines of trespass and nuisance, which are private law doctrines that allow property owners to complain about what other people are doing around them. And actually, these changes have not all been in the direction of stronger individual property rights, or no, they definitely have not been. In particular, nuisance doctrine, with the development of the Industrial Revolution, was weakened to say that a property owner could not complain about any little intrusion onto her property or the uses she was making of that property, but had to put up with some things that were societally important. Other changes have been made by legislatures. The invention of zoning law, relatively early in the 20th century, imposed new unfamiliar limits on what people could do with their property. That was not without controversy. It was not without litigation. They had to go up to the Supreme Court to say, yes, this can be done. It's not inconsistent with property rights, at least not per se inconsistent. And more recently, we've had the development of civil rights laws, which say, for example, you can't refuse to sell your property to somebody on the basis of their race or ethnicity. You can't refuse to rent to them on that basis. And of course, environmental laws, which say that you can't do things with your property that exceed acceptable amounts of harm to the environment. None of those changes have been quick. They've all been the subject of controversy and conflict, and they've been limited to some extent by the doctrine of regulatory takings. The federal Constitution, the Fifth Amendment to the federal Constitution says, nor shall private property be taken for public use without just compensation. And what that's been taken to mean is, of course, the government has to pay if it physically appropriates your property for something like a roadway or a reservoir. And we do that through eminent domain. In California, that can be called, it's condemnation. But it's also the case that the government has to pay if it changes the rules of property ownership too drastically or too quickly. If there's something you used to be able to do with your property, and either the courts or the legislatures tell you, legislature or a regulatory agency tells you, you can't do that anymore. If that goes too far, the government has to pay you for that under the regulatory takings doctrine. And regulatory takings doctrine is a limit on how rapidly and how drastically property rules can change. And this is just sort of the very basics. If there's a permanent physical invasion of property, government has to pay, no matter how small that is. If regulation eliminates all economically beneficial use, the government has to pay, unless that restriction was already inherent in the property rules that applied before, unless it's not new, in other words. If neither of those apply, the government still has to pay if the new restriction is deemed to be unfair. And the Supreme Court has developed a test that says we'll look to the economic impact of the regulation to the extent that it interferes with investment-backed expectations, and to its character, which means how close it is to a physical intrusion. Regulatory takings doctrine, on its face, allocates the cost of change between the government, the public, if you will, and individual property owners. It does not say the government can't change the rules. It says the government has to pay in certain circumstances when it changes the rules. In practice, though, that imposes barriers to change. If the government doesn't think it can afford to pay or would rather put its money towards something else, it won't make the change. Also, takings doctrine allows the rhetoric to be framed in terms of the rights and entitlements of individual property owners. And it turns out that there are political barriers to change that go well beyond when the courts actually require payment. Governments often don't go up to that line in imposing regulations. And my own view is that there already are considerable barriers to change. There are these political barriers because property owners tend to be politically powerful, and people tend to be attached to the status quo. So changes to property doctrine are actually pretty difficult to make, especially when they're weakening the rights of identified individual property owners. And the prospect of takings liability adds another layer of rigidity to that. Now, if you think strong property rights in the hands of individual owners are the best way to adapt to change, that because they facilitate market transactions, then this is all good. We should have a lot of rigidity. I don't think that'll work in the face, actually, I don't think it works for land even before we were totally worried about climate change. But these days, for climate change and water, I think it really does not work, and that we need to worry more about whether our doctrines are sufficiently adaptable than about whether they are sufficiently rigid. All right, so with that little bit of quick background on property law in general, let's talk about water law more specifically. And water law could be more dynamic. It's worth asking, is it really in practice? And should it be? Does it need to be more dynamic than it is? And how would we get there? Well, should it be different? Water is a different kind of resource than land. And if we look at water, this is the South Platte River, which is a river with a lot of sandbars in it, which move over time. The flow of the river goes to different places. It's also fairly variable in terms of the amount of its flow. Water is physically dynamic. It moves in a way that land does not. And important characteristics of it, the amount, the place of flow, the chemistry of it, change more rapidly than land tends to do. Water flows can be extremely variable, as we know, out here in the West. This is just a graph from 1905 to 2005, or I guess 1906 to 2006, of water flows in the Colorado River. And you can see, if you look at the black line, that's the 5-year running average. You can see that's quite variable, even more variable if you look at it from year to year. Where the land is, or how much land there is, doesn't vary on that kind of time scale and in that amount. Another thing we might think makes water different is that it's essential for life, both human life and, of course, aquatic life. And yet another thing that may make water different for these purposes is that market reallocation of water is more difficult than market reallocation of land. And this, of course, is the California Aqueduct. I've just put this picture in here to illustrate that in order to make reallocation of water work, we often have to move water across the landscape, and water's heavy, so that's difficult and expensive to do. When land is transferred, the new owner of the land typically relocates themselves and their activities to the land. But when water is reallocated, it may need to be relocated, and that limits the effectiveness of markets, only if it's practical. We can only get water from places that it's practical to get it. In addition, there are significant political barriers to market reallocation because water reallocation threatens the life of communities, the economic and social life of communities. If a county loses a lot of its water, it's going to lose the economic activities that were supported by that water and the communities that were supported by those economic activities. And because of those political barriers, those realities, the law has imposed various restrictions on market reallocation. And finally, it's difficult because property rights in water are ill-defined in the sense that they may not be fully quantified, like Federal Reserve rights often are not, and they are affected by an overlay of environmental requirements in vague ways that may be difficult to fully understand or quantify. So change in water doctrine may be more important over time than change in the doctrine governing land, property rights in land. Market reallocation is more difficult. It may be more directly supporting human and other life. And maybe water has always been, because of the nature of water, property rights have never, water rights owners have never been entitled to expect the kind of stability that landowners expect. Water law responds to those differences in ways that should facilitate some extent of change. And when I talk about water law here, I'm talking specifically about the law of appropriative rights, the law that governs the Western United States. The Eastern United States is a little bit different, follows riparian law. It too has some doctrines that should facilitate change, but because we're in California and because the West is more affected by the problems that climate change is creating for water systems, I want to focus on appropriative water rights. So there are some elements of appropriative water rights that should facilitate change. One is that all you ever own is the right to use the water. You don't own the physical water the way you own physical land. And you don't own it for all time to the exclusion of all others the way landowners do. You own only the right to use it. And indeed, the state is, to the extent there's something like an owner of water that's like an owner of land, that's the state. And it can parcel out that right to use. If it were starting from a clean slate, it could parcel out those rights to use as it felt necessary. It is constrained today by the fact that those rights have already been penciled out. In California, as in other appropriative rights states, water rights, the right to use water, is limited to reasonable beneficial use. And in California, that's enshrined in our Constitution, Article 10, which says that the right to the use or flow of water is limited to what's reasonably required for the beneficial use to be served, and doesn't include unreasonable use or method of use or method of diversion. In other words, when you hold a water right, you hold only the right to use that water, and that use must be both reasonable and beneficial. In California, there's another doctrine. So the idea that water rights are strictly use rights and that use must be reasonable and beneficial, that's inherent in all Western appropriative rights. In California specifically, there's another layer that ought to help water rights be a little more adaptable to environmental change, and that is that the public trust doctrine limits water rights. And this, of course, is a picture of Tufa Towers at Mono Lake. In 1983, in the Mono Lake case, the California Supreme Court said that Los Angeles's established rights to divert water from Mono Lake tributaries were limited by the public trust doctrine. Los Angeles had held these rights for decades before this case came up to the court. But the court said the state has an obligation to consider and protect public trust resources, and to protect them whenever feasible in allocating or regulating, implementing water rights. And in that case, the state, when it granted LA those rights, had been under the belief that it could not consider the effect on the environment, so it didn't. But the court says later, you should have back then, and in fact, you're still obligated to do so now. And it characterized that obligation as a continuing one, meaning that Los Angeles's rights, in this case, you can't grant new rights. The state can't grant new rights without considering public trust resources, and it has an obligation to reconsider existing rights when there are impacts on the public trust doctrine. So there are these doctrines that seem to make water rights more flexible, more adaptable than rights in land might ordinarily be. But as a pragmatic matter, there are still pressures towards stability. And those have limited the impact of these other doctrines, the extent to which water rights actually have changed and the speed of that. So this idea that water rights are just use rights, that means they could have been limited in time at the outset. And there are places that limit water rights in time, that only give them out for a certain number of years. But that's not the approach that was taken historically in the West generally or in California. Water rights were given in perpetuity. So what you hold, if you hold a water right, is the right to use it, to use that amount of water at that season from that place for that use forever. Since California started giving out these water rights in the late 1800s, things have changed quite a lot. And the people who got those early water rights, which are the most senior ones and have priority under the appropriative rights system. In other words, the oldest rights have to be satisfied before newer rights can be satisfied, and there's only so much water there. So the most secure water rights, and in many cases, the largest amount of water rights, are held by people who they are held and indeed must continue to be used for the beneficial uses for which they were granted. What that means in practice is that what we might now regard as low economic value agriculture holds enormous amounts of an enormous proportion of the water rights in California. And what seems to be much higher economic value municipal use holds less. And we might or might not think the environmental uses at risk have substantial economic value. They have, at a minimum, social value, and they tend to be the most junior rights of all. That would be fine if market reallocation was easy. At least the economic piece of that would be fine. If cities could just easily buy out farmers, that we would get that kind of reallocation. There's been certainly some reallocation through markets from ag use to urban use, but it's difficult enough that there hasn't been as much as would seem economically efficient. And environmental uses, if you think those are important, they're often not going to win the economic efficiency game because they're supporting non-market uses. What about the limitation to reasonable and beneficial use? Well, those seem pretty flexible, right? Reasonable is a concept that would seem to change over time. For example, reasonable would seem to mean in light of current circumstances, in light of current knowledge, in light of current societal values. But the law being conservative, the interpretation of reasonable has tended to be pretty conservative too in all the places that the law uses it. So, for example, in torts doctrine, negligence doctrine, we look to what a reasonable person would have done. Or under a number of our environmental regulations, we might look to what's reasonable to do to control pollution. When we use that term, we tend to be importing the status quo. And to say somebody that's behaving in a way that is common or has been socially accepted is behaving reasonably. And the interpretation does change, but it hasn't, at least in the past, changed very rapidly. And beneficial use, that's a term that it's a term of art. It too should change over time as the circumstances change, as societal values change. Beneficial use essentially means a use that society wants to encourage. And it definitely has expanded over time. Used to mean manufacturing, domestic use, agriculture, mining. Now it definitely includes recreational uses and environmental protection. But it's not contracted. So if what we think about, or at least only very rarely, at least if what we think we need to do is to reallocate water away from existing uses. The concept of beneficial uses has expanded water, the ability to get water rights to new kinds of uses. It hasn't really contracted the ability it hasn't really contracted what are considered acceptable uses, nor has it typically distinguished within broad categories. So it hasn't generally been used to say, well, you have to grow the most water efficient crop for your area or something like that. You know, if agriculture is a beneficial use, then agriculture is a beneficial use. Oh my goodness. Sorry about that. A branch of a tree just fell on my house. I'll have to check that out after this. The public trust doctrine also has not brought as much change as one might have expected. And again, I think we see here the kind of inherent conservativeness of the law. So the Mono Lake case seemed to say to the state water board and the state courts that property rights in water have to be reconsidered whenever they turn out to be causing problems for public trust resources. Well, these days, property rights in water are for sure causing problems for a lot of public trust resources. But the Mono Lake case hasn't done much about that. It took a long time. It did get to reconsideration and reevaluation of the water rights that Los Angeles held. And it did help persuade Los Angeles to start emphasizing water conservation and reducing demand for water. But outside of that context, where that took many, many years, it's not been an effective driver of reallocation. Now, it has done things. The state board now explicitly does consider public trust resources when it creates new water rights. But for water that's already been allocated, aside from Mono Lake, there's been very little use of the public trust doctrine to try to contract that. Well, there may, however, that was probably a pretty pessimistic look, right? Hey, water law doctrine has all these pieces that ought to facilitate adaptability, but when you look at those pieces, they haven't played out in the way that they haven't played out as aggressively adaptive. They've been, to a large extent, co-opted by the conservative nature of law. But I think there are some recent signs of hope, and one of them is what got Safik to ask me to do this talk. But another one is one that I just need to add in. So one thing is that with the driver of the most recent severe statewide drought, the State Water Board has taken a more aggressive stance towards the reasonable use doctrine. And in at least to some extent, it's gotten away with that, meaning that the courts have upheld, the state courts have upheld that authority. And a very recent example from this summer is the Stanford Vina Ranch Irrigation Company case, where there was a curtailment. That means that the state board told some water users that they could not take all the water that their water right on paper allowed them to take, because that would reduce the flow of water in a couple of creeks below what was needed for fish. And the court said that the irrigators, the water users, challenged the board's authority to do that. And the court said the board has that authority, that it can declare diversions of water unreasonable where the diversions would harm public trust resources by causing the flow of water to drop below levels required to support in-stream resources. So first of all, the board gets to redefine reasonableness, at least when doing so is in a way that reduces the strength of individual property rights, at least when doing so protects public trust resources. And the court went on to say, this curtailment was not a taking requiring compensation. So even though the board said, you can't use the full extent of your water right, that wasn't a taking because it was supported by the board's authority to define reasonableness and the underlying requirement that the underlying limitation of water rights to reasonable use. So that was a fairly sudden change in response to drought, and it was upheld. It was both made and upheld. And there's another case that the court relied on in Stanford Vina, from that, again, the board took a more aggressive stance when it saw that public trust resources were being harmed by diversions, and it redefined what was reasonable use, or at least made explicit limitations on reasonable use. And that's the Light case, which upheld, the board had adopted some rules restricting the use of water for frost protection of grapes in wine country. And it said that it would be unreasonable to divert water for that purpose unless there was a water demand management program in place that would ensure that there was enough water left in the stream that the young salmon wouldn't be harmed by the loss of water. So together, Stanford, Vina, and Light are pretty strong endorsement by at least the California appellate courts of the authority of the board to define reasonable use in a way that restricts pre-existing rights, and to do so without paying the water rights users. The other recent development, which is the one that Safik had pointed out and asked me originally to talk about, is that the US Supreme Court this summer refused to take up a water takings case. And that was Bailey versus United States. That's part of this long running, it's the latest decision in this very long running takings dispute that started with the Bureau of Reclamation in 2001, closing the headgates of the Klamath Project temporarily and stopping deliveries to project irrigators in order to protect endangered and threatened fish, both upstream in Upper Klamath Lake and downstream in the Klamath River system. And the water users brought a takings claim where they said that you've deprived us of our property rights, and therefore you have to pay us. And that's been up and down and through a number of courts. It went to the Ninth Circuit, had to go up to the, it was referred at one point to the Oregon courts for an explanation of what the state property rights in water were. And it went back to the Court of Claims and the Federal Circuit, which eventually decided, the Federal Circuit ends up holding that there are tribal rights in that system which are senior to those of the project water users and which encompass water needed to protect fish, because the tribes have fishing rights for those fish. And so their water rights encompass keeping those fish around. And therefore, no property rights had been impaired or interfered with because the restrictions on property rights were really only recognizing the tribal senior water rights. That's important in a couple of ways, I think. One is that the Federal Circuit's decision reminds us that there's history that's difficult, but there's history that helps too. And the tribal rights tend to be the most senior rights in any of the Western systems. They go back to time immemorial, or at least to the creation of tribal reservations. So to the extent that they encompass fish protection, for those of us who are interested in fish protection, that can be very helpful. Another thing that's important here is that the Supreme Court, that the Federal Circuit held that there didn't have to be a state procedure to quantify the tribal rights before they had this effect. That helps on the takings side, because if there was no such procedure, then the state might not be able, the federal government might not be able to claim that it only did what it was required to claim. And there's an earlier Endangered Species Act takings case that held that the US government had committed a taking when it imposed restrictions on at Tulare Lake Basin, because there might well be public trust restrictions, but the state hadn't officially declared them. So this seems a little bit more generous. And the Supreme Court not taking this up is a good thing, because in the past, the Supreme Court has sometimes seemed to be reaching out to make new takings law protective of individual property rights holders. And it could have done that here, and it declined to do so. So let me just sum up in a couple more minutes. if you believe, as I do, that water rights need to adapt in the face of climate change, if there's less water, we're already at the point in California where demands for water exceed supply. If there's less and it's available at different times, that's going to mean we need to fairly rapidly change what we're doing. I don't think markets can do that. So the question is, can changes to legal doctrine do that? Well, the first thing to say is that market reallocation can help. I don't want to say that markets are useless. I just don't think they can do enough quickly enough. And because I think it's important to protect the environment to some extent, I really think they won't do that. So changes in water rights doctrine that are rapid enough and go far enough will require, I think, three things. One is a US Supreme Court that interprets takings doctrine in a way that leaves some room for adjustment. And perhaps the Bailey, the fact that the court didn't take cert in Bailey, and the fact that the Federal Circuit, which in the past has been seen as very friendly to individual property rights, made the decision that it did, maybe that means that the federal courts, there's at least some hope that they will leave enough room for adjustment at the state level. Then we also need the state to want to make adjustments and to do so. And that requires two other things. One is leadership at the state level. And I think the Light case and the Stanford Vina case, those don't happen unless the State Water Board is more aggressive at doing reallocation than it has historically been. And that means it needs courageous leadership, which it had at that time. And we'll see if it continues to have that in the future. And then the third thing it needs, which makes the leadership easier, is a crisis sufficient to focus public attention on the shortcomings of current doctrine. And that's maybe one silver lining in the big cloud that is statewide drought, past and future, is that a severe drought is a crisis that definitely focuses public attention. And I think the next severe drought in California is highly likely to move water at least from agricultural, low-value ag use to municipal use. I think there's an open question the extent to which it will result in moving water to the environment, or it will result in holding water for environmental uses. And I know I've gone a bit over the time I was supposed to take, so I will stop there and just say thank you again for having me here. And if you want to follow up directly with me after this, there's my email address, which you can also easily find by looking on the law school's website. Thanks. I'll stop sharing my screen.
Thank you, Holly. That was awesome. Yeah, I think now we will open up. We still have 9 minutes to go. So we'll open up for Q&A, and I think we already have some questions here on the chat. So I'm going to read out. So the first question is, what about critical habitat designation? I believe that's referring to the land rights.
Yeah, I can say a couple things about critical habitat designation. It doesn't by itself restrict anybody's rights. And so it's not a taking to impose a critical habitat designation if that's the question. The only thing it does is it imposes some duties on the federal government in consultation. It's widely perceived as heavily restricting private property rights, but it only does that to the extent that the private property owner needs a federal permit to do development. And at that point, it would be subject to the taking doctrine test.
Good. The second question, I think it's a two-part question. Had the public trust doctrine existed before the Mono Lake case, or was it discovered in that case? And then the second part.
Yes, sorry.
I will let you answer that, and then we'll read the second one. Sorry.
So the answer to that part is it existed before. The story that's told in the courts about the public trust doctrine is that it's always existed. But it was announced in California beginning in the 1970s. And it was announced as a restriction on what people could do with their land, actually. And in the Mono Lake case, the court says it applies to water rights. That's what's new there.
So second part to that question, is the public trust doctrine was well described, or is it determined on a case-by-case basis?
It's not well described. In fact, the way it's described is that there has to be some level of protection for these public trust resources, which include, among others, access to waterways. And the one that comes out in Mono Lake is it includes protection of aquatic ecosystems. But the level of protection that has to be imposed is not well described. And in Mono Lake, the court is careful to say only to the extent feasible. It's not an absolute requirement. So it ends up being something that has to be worked out in every individual case.
Okay, the next question is from Chris Hoon. In California, is the State Water Resources Control Board the sole penultimate authority to define public trust, and what is reasonable in terms of water rights?
No, I would say the courts also have a role to play. I think that the Light case, the Stanford Vina case, those suggest that the board has a clear role in defining reasonable use. The legislature surely has a role in defining reasonable use as well. And the courts would be the ultimate check, I think, on either whether use was being made that was unreasonable or whether a redefinition of reasonable use had gone too far. And I think the same thing is true of the public trust. You know, when in the Mono Lake case, the court refuses to say exactly what the public trust requires there and refers it back to the board, making it clear that the board does have a role. I think, again, the legislature would have a role and the courts would have a role.
I hope that answers the question. The next question is from Catherine Jarvis Sean or Sheen. I hope I got that right. What are the legal grounds that allow Sigma to restrict use without compensation?
We'll see. I think that's a good question that remains to be played out, right? I mean, maybe it's unreasonable to use groundwater. Groundwater too can only be used reasonably. And maybe it's unreasonable to use it in a way that a groundwater management plan says you can't. Would that mean you don't get compensation? Maybe, maybe not. We'd have to go through the takings litigation test to see that.
Okay, there's a comment from Andrew Ayers. Is it worth noting that empirical evidence demonstrates that critical habitat designations reduce property value?
Yeah, so sure. That's because landowners think they restrict use, even though there's very little empirical evidence that they do that. In fact, I think Dave Owen over at Hastings has done an empirical study of critical habitat, how it plays out in consultation. And essentially, critical habitat alone never drives a finding that something can't happen under the Endangered Species Act.
Yeah, the next question is from Anshika. Do you think land retirement or changing land use will make water allocation and conservation more efficient?
Maybe.
I believe she's referring land retirement with respect to Sigma.
Oh, I guess I don't know. I don't know. I could imagine that retirement of land that has been in low value agriculture could free up water for other uses. Part of the problem is if you're in an over-allocated system, that water isn't free. It might go to the junior appropriators who haven't been getting their full appropriation.
Yeah. All right. So again, I think it's a comment to your earlier response to the question related to the State Water Resources Control Board. So you have praised the recent behavior of the State Water Resources Control Board, but to users, their decisions were in fact takings, regardless of the view of the court. Objectively, they are correct. So isn't the board guilty of a kind of bullying by taking without compensation?
Well, let me say two things about that. Absolutely, there are different views about what's the highest and best use of water, for sure. Mine tends to include fish, but other people disagree. And property owners always, always, always think that any change to what they're allowed to do is a taking. They've lost something. Absolutely. But the question for the courts, the takings question, is whether they've lost something for which they're entitled to be paid. And objectively, that's a question of law. And what the courts determine is the answer. So yes, people have lost something. Whether they're entitled to be paid depends on how the courts construe takings doctrine. I freely admit I want the courts to see takings doctrine fairly narrowly because that serves my values. Water users want the courts to see takings doctrine broadly because that serves theirs. And I think, is the board guilty of bullying? Well, the board is guilty of changing its view over time of what's most important in implementing water rights. And whether that's bullying or not depends on where you stand, I think.
Okay, so let's see how many questions we can take. We're in the last minute. So let's quickly give some other people a chance. This is Catherine is again following up on her earlier question. I often hear that farmers are concerned that if they don't use water that they're allocated, they will lose the right to it in subsequent years. Are there actually legal grounds for this concern? If not, have there been ground for this in the past? Where does this concern come from?
Yeah, there actually are grounds for concern about this, that because water rights are only use rights, if you don't use your water, you can lose the rights. Because the idea has always been with appropriative rights that they're not supposed to support speculation. So I can't just lock up water that I don't need in the hope that it will become more and more valuable, right? So there is a doctrine that is use it or lose it. It's actually, again, I think this is a place where it's perceived as being stronger than it has been, but it is out there. And one thing that it is possible to do a short-term transaction to sell your rights for 1 year or another year, and that would be enough to make sure they were being used.
Okay, the last question before I have to end this call from Michelle Gilmore. Since courts tend to follow precedent, do you think that legal cases may be the most efficient way forward to change water rights doctrine, or at least the implementation of it? This question I wanted to ask, considering what happened in Nevada a couple of days ago, right? The California court ruling actually gives hope of the public trust doctrine, but the new ruling that came out in Nevada is exactly opposite to that. So two neighboring states interpreting the same thing very differently.
Yeah, it's a good question whether what's the most efficient way to do this. Some courts are very conservative and change their doctrine very slowly. Other courts are less conservative, and this changes over time too. It depends who the judges are, how rapidly they're willing to change. They always do have to explain any departure from the past. That's what precedent requires. My own view is that courts are unlikely to do this on their own, in large part because water has become such an administrative doctrine that the law of water is these days in the West a law of legislation and regulation. And the courts are, I don't think they're going to step in if the water board or similar administrative agency doesn't, and say, not very often anyway, and say, this is what the water board should have done. What they're going to say is, we don't want to touch that with a 10-foot pole like in Mono Lake. We might tell you what the doctrine is, but we're going to send implementation of it to the administrative agency. So I think legislators and bureaucrats are where change is going to have to come from.
All right. On that high note, I have to end this presentation. So thanks, Holly, for joining us. We're going to give you a virtual clap, or thumbs up rather.
Yeah. Thank you.
Okay. So thanks everyone for joining, and do tune in for our next speaker. That's every third Friday of the month from 3 to 4, and we'll send out the announcement. All right. Have a wonderful weekend.
Thank you so much, Holly. Really enjoyed the talk.
Thanks. My pleasure.